with all of these these rulings coming down and this broad definition of what standing is and how a plaintiff can get standing, we're going to see more PAGA suits, and with that comes increased litigation costs. And along with that, we need to be sure that the arbitration agreements are tightened up. But with the courts focusing on these arbitration agreements, the employer needs to decide whether the employer wants to enforce the arbitration agreement. And you may be wondering, well, why am I going to do an arbitration agreement? Why am I going through all of these steps to have an arbitration agreement if I'm not going to enforce it? Well, in an individual arbitration, the arbitrator is going to focus in on the strengths and weaknesses of those individual claims. So the employer wants to consider, are those individual claims strong or weak? If the employer has a strong defense to those claims, the employer may be able to win the arbitration, and that potentially could be binding on the representative case. Now, there's a chance that a lot of plaintiffs' counsel will try to find a new representative plaintiff and ask the court to relate that back to the original filing. And so that's something to consider when deciding whether or not to enforce these arbitration agreements. If the employer doesn't have a great defense against the individual claims and there's a weaker defense, a consideration is that a loss in arbitration can lead to increased liability. So again, as Anthony mentioned earlier, an employee really only needs to show one violation under the labor code to be an aggrieved employee to bring a claim for other violations under the labor code. And that time we spend in arbitration may lead to an increase in the PAGA period, as well as an increase in liability in the representative matter. So it's important to consult with counsel to decide whether or not to enforce these arbitration agreements if you're faced with a PAGA lawsuit. Now, some of you may already have PAGA lawsuits pending, and a lot of them have been stayed pending this decision in Uber. And so now the question is, well, what do we do? What does that impact on our current PAGA litigation? Well, the first issue is, we have standing, and we get standing in two different forms. One is the individual PAGA claims will go to arbitration, and those non-individual PAGA claims would be in court. Well, while those individual arbitration is in court, what do we do with that the individual claims are in arbitration. What do we do with those non-individual in court? The California Code of Civil Procedure has a mandatory stay of civil action. So what it says is that if a court has ordered arbitration of any of the issues involved in a civil action, the court, upon a motion of a party, must stay the action pending the arbitration. And an argument that we should be prepared for is that the PAGA representative claim should not be stayed, and that instead it should be concurrently litigated with that individual PAGA claim in arbitration.
I wanted to jump in really quick on that too, Pooja. I think the California Supreme Court in this Adolph decision made it clear, really drew a roadmap for employers on how to continue defending against these PAGA claims. And as Pooja mentioned, this Code of Civil Procedure section 1281.4, employers need to start enforcing that provision, maybe, and we'll talk about it, I'm jumping ahead a little bit, having that included in the arbitration agreement, but it's so critical. The language in that section requires a mandatory stay of the civil action, and employers need to be upfront, very vocal about that early in the case and enforcing that provision in any litigation.
Yeah, and one of the huge benefits of enforcing that is that the employer is not fighting both the individual and the non-individual at the same time. You're really able to focus in on that individual PAGA in arbitration before you have to focus in on that non-individual PAGA in court. So, going to the impact on the current litigation, there's a few options here that based off of where we are in the case and discussion, with your counsel, there's different options to take here. And these are just some of the different ideas and some of the different thoughts that we've had on where these cases are going to be going. So one option is to continue to enforce the class action waivers, move to compel that individual PAGA claim to arbitration, and ask that court under that CCP code to stay the representative PAGA claim until the arbitration is concluded. And as we discussed, that kind of allows the employer to focus in on that individual PAGA claim. It has the potential, if the arbitrator determines that there's no violations, then it has the potential for the employer to use that in the representative PAGA case in court. There's some benefits with going to arbitration. Some of them do include reduced fees and costs. There's always flexibility to go to mediation. A lot of times timing is quicker in arbitration versus in court. And then the next option is, if there is not a strong defense to the individual PAGA arbitration, something we discussed a little earlier is maybe the employer does not want to enforce the arbitration agreement and allow all of it to be litigated together in court. And that kind of goes with option 3 as well, is that let's not make a decision one way or another. Let's defend everything together in court and potentially discuss doing a global mediation with everything and defend everything all at the same time in front of civil court.